So this is video 2 for the weekend of April 1st and 2nd. We're finishing up civil rights here. You have, in 1968, a turning point in the civil rights movement whenever you have MLK murdered inside of Memphis, Tennessee. To just kind of catch you up, since we finished off everything else, King received the Nobel Peace Prize in '64 for his various efforts because he always stuck to these nonviolent approaches. But even by the mid-'60s, Americans, or black Americans, were giving him more heat, saying that nonviolent protests weren't working anymore. He actually had done some attempts at peaceful marches in the North, like in Chicago, but they had little success because it's a different beast there, essentially. You know, their segregation is a lot different than what you have in the South. King broke with Johnson over Vietnam in '67 because he criticizes how many blacks are being drafted into the war, because he basically argued rightfully that there are a lot of African Americans were being drafted more than they should be because a lot of working class people were being drafted, and since African Americans were lower class, you have a lot more African Americans being drafted than they should be being drafted at this point. So that's one issue that he addresses. The other issue that he addresses is also the fact that because the Great Society suffers, it also hurts African American communities. So he also does kind of come out and criticizes Johnson in the late '60s as a result. But King goes to Memphis, Tennessee in April '68 to address this garbage worker strike that African Americans they were putting on. And while he was sitting at his hotel balcony in Memphis, he's shot from across the street by a man named James Earl Ray, a white man named James Earl Ray. Unfortunately, after he's killed, over 160 cities are going to break out into riots. Over 160 cities have riots, which is obviously not what the man would have wanted. But over 160 cities break out into riots as a result of these protests, over his death in April '68. And in all those riots, you can also see 96 people die as well, too. And you can see some pictures of riots down here as well. So the death and what happened here in the riots reveal a lot of anger and frustration in the North and South, that things hadn't necessarily changed for the better. And, you know, the '60s were a very frustrating time. A lot of protests were happening, but a lot of these issues won't be addressed right away. So as far as legacy goes, you know, after King's death, the civil rights movement kind of tapers off. Johnson does pass a civil rights bill in '68, so he passes a second one. It's on the screen, though, that addresses housing, a discrimination in housing, make it to where you can't discriminate whenever you give out people's house, whenever you sell a house. But, you know, it doesn't happen overnight, but you're going to see more African Americans register to vote. You're going to see more African Americans going to school, more African Americans graduating college and high school. They're going to start teaching African American cultural and history classes and literature classes in college by the '70s. So it's slowly but surely happening, just not all at once. You also see then two other important legacies that come out of all this: affirmative action, desegregation, busing. So affirmative action is a policy that the federal government implements and a lot of businesses have to deal with in college campuses. Basically what affirmative action means is that if you are some kind of group that has been historically hurt or limited by society, you might get a leg up when it comes to getting a job or when it comes to getting into college. So like, for example, I'll give you just a rough idea about how this works. If LSU took in 100 college students this year as freshmen, instead of automatically taking the top 100 best candidates, let's say you reserve 20 of those spots for minorities. So even if, no matter how it rolls out, you have to have at least 20 spots of that 100 set aside for minorities, whether or not they actually achieve the highest scores. So you might actually have some who achieved what they need to achieve in terms of admissions, but you still have to have a good representation of African Americans, Latinos, women, whatever the case is. And so a lot of businesses in college now have these affirmative action quotas they still even use now, to where they won't just take in a bunch of white people or all whites. They're going to make sure they have a good balance of different minorities, African Americans, Latinos. They're going to have women, which is good and bad because obviously these people weren't getting into colleges as much as they should back in the day. But at the same time, some people have even argued today that it should go away, that it's out of date, because what if you do have people who are more qualified, but just because they're not a minority, they don't get the spot. So it's still very controversial even now, and some people feel like these ideas should go away. But when it comes to jobs and when it comes to colleges, affirmative action is still around, and the idea is that you want to make sure that you're hiring people, minorities, and so on, so you're not discriminating against people based on a certain race or color or creed or something. The other thing that happens is busing. In the 1970s, school districts couldn't fix where folks lived. Like Baton Rouge, you have an area where a lot of blacks live, and you have an area where a lot of whites live. But you can't force people to move. So how do you fix schools? How do you help schools desegregate if they live in areas that are all black, all white? So what happens then is that they begin to desegregate schools by busing. So they'll take kids from like Scotlandville and bus them to like Lehigh, and they'll take kids from Lehigh area and bus them to Scotlandville. That way they're forcing all the schools in your district to basically desegregate by busing. They take you from one school to the other. So it's great in terms of trying to make the school more racially balanced and actually expose all these kids to the same kind of education. But at the same time, it kills a lot of school support, because now you have white families taking their kids out of schools, and it hurts those schools still. Like you look at EBR, that's what happened to EBR. Which, one of the reasons why Zachary High got out of EBR in the first place 12 years ago is because we were being subjected to some of this busing stuff, and we didn't want to do it anymore. And so we broke out and made our own school system, and we're racially balanced as it is now. But the point is, they would have to move, a lot of, if your kids don't go to your school that's right down the street, the parents aren't going to support it, which means they lose a lot of their funding and all other kinds of parental, support and fundraisers, all these other kind of things. So it hurts them. But these are two things that we still deal with today that come out of this era. Some think maybe out of date now, but at least were very necessary back when they were first formed in the late 60s, early 70s. So that's the end of civil rights. We're going to move on now to the Warren Court individual stuff. So you see here I have a list of court cases. You do need to be aware of these court cases in general, but I'm going to give you a general note about the Warren Court first. So this is what you need to know for sure, and the court cases I'm going to explain to you separately. So the Chief Justice of SCOTUS from 1953 to 1969 was Earl Warren, who had impact like John Marshall. John Marshall was like the number one guy to know for the Supreme Court. Then it's going to be Earl Warren. He was the guy who ruled in the Brown case, so he's the same justice who oversaw the Brown case back in '54. In the 60s, he's going to oversee several criminal justice, states, political systems, and definition of rights cases. So his court has huge impact on how the federal government operates, just like John Marshall did. And he tries to focus a lot more on individual rights and a more liberalized court. So the main note to have about him is that his court cases make the government larger, more active, and more liberal. So all these court cases are going to result in a more active government, a more active judicial branch, and a more liberal government overall, as opposed to what had been happening at that point. Now, with the court cases, these are the ones you need to know. Just be aware of the EOC as well as the AP test. But I already gave you these court cases on that court sheet a long time ago, so I'm pretty sure that sheet is on Moodle, and I'll verify that it is. But make sure that you go back over these. I'm just going to run through them real quick, but it's going to be up to you on your own to make sure that you know the main idea. Like, don't worry about the background of the case. Just know what the main result of each case is. So I'm going to run through them real quick. Matt versus Ohio is illegal to seize evidence that cannot be used in court. So basically, if there's not a warrant to get it, you can't use it. Gideon versus Wainwright. It says that it requires states to provide counsel to people who can't afford one. So if you can't afford your own counsel, then Gideon versus Wainwright says that you must have the court provide you one, no matter how poor you are, how wealthy you are. Escobedo versus Illinois. Require the police to tell the arrested of their rights to remain silent. So Escobedo says that whenever you get arrested, you must be told that you have the right to remain silent as soon as you're arrested. And then the Miranda versus Arizona case in '66, it was an extension of Escobedo and included the right to a lawyer being present during questioning. So Miranda also, this is where you have your Miranda rights come from. Like if you ever get arrested, you're going to hear the Miranda rights where it tells you have the right to remain silent. Anything you say will be used against you in a court of law. If you cannot afford an attorney, the court will appoint one for you. So all these rights are now standard for police to say to you because of those two cases, Escobedo and Miranda. So those first ones, we're all dealing with criminal justice. Then you have freedom of expression. Yates versus U.S. The First Amendment protected radical and revolutionary speech unless it presented a clear and present danger. So Yates versus U.S. protected radical and revolutionary speech unless it created a clear and present danger. So it's kind of extension from that previous Schenck versus U.S., but more of a clarification. Ingalls versus Vitale in 62 required prayers and the Bible readings in public schools to go away. It said prayers in public school violated church and state, so this ended legal prayer in schools. In Griswold versus Connecticut, basically the state of Connecticut had laws saying you could not buy contraceptives or like birth control, and so this court case said that's a violation of privacy, and you should not be able to rule what people use or don't use in terms of their household and marriages and so on. So this ruled it to where contraceptives could be purchased legally and overturn Connecticut's law, and eventually other states will have to do the same, and makes birth control more available to people in the 60s, which we're going to talk more about that later on. And the last one is reapportionment. So all those dealt with freedom of expression. The last thing we're going to talk about here is reapportionment. It was very common before 62 to have states draw their districts that favor rural areas, especially in the South. So a lot of districts for Congress were drawn in a way that rural areas got unequal representation from the government. Like a lot of rural areas, because that had been kind of the tradition, got a lot of influence. So even if you had New Orleans might only be like a district, whereas you have like multiple districts in other rural parishes, which just didn't seem fair. So in Baker versus Carr in 62, the Supreme Court declared that those practices of gerrymandering your districts were unconstitutional. And they ruled that all districts must be drawn in a way that are equally population proportional. So as of 62, all congressional districts will have to be drawn equally and proportional, not based on where you want to draw them, but where population. So like as of today, every district roughly represents about 650,000 people in every state, and that's for the House of Representatives. There's actually a follow-up case to this called the Reynolds versus Sims. Reynolds versus Sims comes out a couple years later, and it does basically the same thing, but for states. So it says the same thing, but for state districts, not for congressional districts. So to wrap this section up, the Warren's court decision to defend unpopular groups and freedom of criminals provoked controversy. Some people felt like, well, if you're guilty, you shouldn't get a lawyer. If you're guilty, you don't need a lawyer to protect you because you're innocent. But obviously, if you don't have that knowledge, it's not really fair. So a lot of conservatives didn't like these court rulings, but they couldn't do anything about it. But these decisions held a profound and pervasive revolution in the interpretation of rights. That now you have a much more liberalized government, and your rights are now much more protected as a result of these court cases, and they still affect us even today as a result. So the Warren court case was extremely impactful as a result. Okay. All right, so I'm going to stop second video there. I'm going to do a third video, and that's going to be it for the weekend.